In this video, we will discuss confidentiality as well as informed consent laws. So confidentiality refers to the act of protecting clients' private information so that to the greatest extent possible, their information is not provided to anyone without their explicit consent. So all the information gathered should really just stay within the provider and the people authorized to work with the provider and the client. The client may want to share with other providers or with family, and they would need to kind of go through a process of informed consent to share information with other parties. And confidentiality is very, very important in clinical work. And so it's emphasized in both the general principles and the ethical standards, because it's important to provide services without sharing all the personal details offered in the process. Part of this is we want clients to trust therapists. So it's a very important part of the field, not only with specific clients and therapists, but just as a general trust of the field to keep confidential information. And so, as we reviewed in the last video, there's kind of a difference between clear-cut legal standards, ethical standards in the APA code, and then these general principles. So things like child abuse or elder abuse, there is a clear legal standard for breaking confidentiality to report this information. And in fact, the psychologist or therapist or other mandatory reporter can get in trouble for not reporting. So if there's any hint that a child is in danger of being harmed or has been harmed, the psychologist has to report to the proper authorities. But there can be ethical dilemmas that arise when the therapist is weighing the pros and cons of whether or not they should break confidentiality, when they're not required to do so, but when there's consequences to both options. So we're going to talk through kind of a landmark case called the Tarasoff case that has really informed how clinical psychologists report certain things that there is no clear-cut legal standard for. So this puts psychologists in a really difficult position. So you can get sued for breaking confidentiality unnecessarily, but you can also get sued for wrongful death or other adverse outcome. So if you have a client who, for example, is saying they want to harm themselves or someone else, the psychologist really has to weigh the pros and cons of either direction they're going to take. And so back in the 1960s, there was this case that is now referred to as the Tarasoff case. And this led to this idea of a psychologist now has the duty to warn. So I'm going to kind of talk through the case, and then we'll talk about how it has implications for the field today. So back in 1969, there was a student, Prosenjit Potter, who's at UC Berkeley. And he was seeing a therapist, a psychologist at the University Counseling Center at Berkeley. And he told his therapist that he wanted to kill another student, Tatiana Tarasoff, after their relationship did not progress in the way he had hoped. So they had gone out on a couple dates. She was no longer interested, and that made him unhappy. And so he had a really hard time kind of dealing with this. So he was thinking about wanting to harm her. So his psychologist actually did break confidentiality. He told UC Berkeley campus police of the threat. The police came and interviewed Potter, but they did not detain him. They let him go, and he never came back to therapy. Unfortunately, 2 months later, Potter ended up murdering Tarasoff. So Tarasoff's family actually successfully sued Dr. Moore for wrongful death. So they were saying that simply calling campus police was not sufficient and that the psychologist should have done more to protect Tarasoff. And this established this legal duty to warn. So this case sort of established now that psychologists actually have to, they're obligated to warn people if they're aware of danger to them. So instead of just calling campus police, now Dr. Moore should have contacted Tarasoff and her family directly. So a later hearing actually modified this duty to warn to be more of like a duty to protect, because Dr. Moore actually did warn by calling campus police, and now they're saying that was not sufficient. So he had to take further actions to protect Tarasoff. And so this legal case happened over 50 years ago, but at present, different states actually still have different rules regarding when there is a duty to protect and what legal obligations psychologists have. So when we look at TerraSoft laws by state, we can see that there is variation in how the laws are applied. So in most states, including Hawaii, there is a mandatory duty to warn or protect. So if a client says they are going to harm someone in the future, the psychologist has a mandatory, they must report this, otherwise they could face legal trouble. There are other states where if the psychologist chooses to breach confidentiality because of a threat, they will be protected from being sued for breaching confidentiality. So in a way, this protects the psychologist, but it doesn't force them to break confidentiality. And then there's just a handful of states that actually kind of have no laws or guidance around it. And so there's not a legal obligation to report, and there's also not a legal obligation to protect the psychologist from unnecessary breaches of confidentiality. So it can be helpful to return to our 5 general ethical principles and think about how they would apply to the TerraSoft case. And there's no one right answer here. I think there's different ways in which the principles can be involved in this case. When I take a moment to look, I look at these two as being kind of opposed to each other, specifically in the TerraSoft case. So on one hand, you have a client who is, experiencing a psychological problem. He's wanting to harm someone else because he's having these negative emotions. And breaching this client's confidentiality is certainly going to harm the therapeutic relationship. And it may be unlikely that that client feels comfortable with a therapist again. And so on the client side, we need to consider to what extent is this harming the client or preventing benefit to the client. On the other hand, psychologists have a responsibility to society. We want people to trust us. We want to do good for society. And so warning a potential victim is keeping them safe. And so these are kind of opposed to each other, though, because on one hand, if we don't breach confidentiality, then something bad might happen, and that risks the trust that society has in us and our responsibility to bring well-being to society. But on the other hand, if we do breach confidentiality, it will likely harm the therapeutic relationship. If you have any other thoughts about how other ethical principles come into play here, feel free and drop it in the comments. A related topic is how to handle confidentiality for children and adolescents. And the essence of the question here is how much information should psychologists reveal to parents of the children they are working with? So children and teenagers, they might choose to not discuss personal topics with their therapist if they're worried that the information is going to then be given to their parents. However, on the other hand, as legal guardians, caregivers are entitled to information regarding their child's therapy services in most cases. So oftentimes, this is what I do. I think it's really helpful. It's helpful to make a specific arrangement with the parents at the very beginning of services that outline what information will be shared and what information won't be shared. I always like to emphasize that to really maximize the benefits of therapy, it helps if the child or teenager can feel safe and have some kind of their own space to work through some of these issues before the family gets all the information. And I always let them know that if the child is in danger, of course, I will share information. And parents usually agree to this. However, they don't have to, and they might change their mind later. And so it's not necessarily a clear-cut solution. And so because of this, psychologists often have to exercise their judgment about what information to share with parents. So if a child shares information about potentially unsafe behavior that the parents don't know about, that might be a situation in which the psychologist decides to give the parents more information. However, as you can imagine, this could really damage the rapport and break the bond of trust between the child and the clinician. In contrast, if it's involving child abuse, whether it's suspected or confirmed, psychologists are mandated to report that. So, in some cases, it's very clear cut that confidentiality needs to be breached, to let the parents know and even let other proper authorities know. But the child could be in an unsafe situation that is a little bit more blurry, something like substance use or self-harm. The therapist is really going to need to think about kind of like the function of letting the parents know and what is the best way to keep the client safe. So we'll talk through an example. So in this example, we have Danica. She's a 17-year-old girl in therapy. Her parents have agreed that, she deserves some confidentiality. They don't need to hear the full content of sessions. However, they do insist that they be informed of any harm or danger that she might experience. And so Danica shares with her therapist that she drinks alcohol approximately once per week, does not get drunk, that she cut her forearm with a razor blade once a few months ago, and one night she was a passenger in a car driven by a friend who may have been high on marijuana. And so these are examples where there's not necessarily one right answer of how a therapist should handle this. So I'm curious to hear what you guys think. Do any of these behaviors or situations call for the therapist to inform the parents? And when would you want to inform the parents? So would you tell them the same day that you get this information? Would you give Danica maybe like a few sessions to work up she can tell her parents? And how would this situation be different if she wasn't 17, but she was 14 or 11 or 8? How would that influence your decision on how to proceed here? And again, thinking about the ethical principles. So which ones come into play in this situation? Feel free and comment what you think. When I take a look, I think about these two. So we have beneficence and non-maleficence. So we're wanting to keep our clients safe. The goal of therapy is to promote positive well-being and prevent harm. But we also want to respect the client's rights and dignity. So especially teenagers, treating them as independent people. In some situations, it's helpful to tell the parents, but in others, it might be more important to respect the teenager's autonomy and how that might influence treatment in the bigger picture. I know things like self-harm and substance use can be very serious, and they're not to be taken lightly. And it's really important for the therapist to look at the overall picture of how therapy is going. In some situations, telling the parents about one incident might actually harm the therapeutic relationship such that you never actually get to fully treat the problem. And so sometimes keeping it confidential might actually be better for the overall picture of keeping the client safe. So these are just some things to consider. Again, there might be other principles at play, and feel free and disagree with these or propose others, but something to think about. So a related issue to confidentiality is the process of informed consent. And so essentially what this is any participant in a research study, in an assessment, in psychotherapy, they must be provided with enough information to be able to make an informed decision about whether or not they want to participate. So this is an essential component of both research and clinical work. And especially in a therapy setting, it's really best thought of as an ongoing process. So this is kind of a way to facilitate a collaborative relationship, to really get the client involved in their own treatment planning and understanding, how mental health services work, how their information will be taken care of, really making sure they understand. And this can really be used to help boost that relationship between the therapist and client. And so related to confidentiality for minors, there's actually an interesting consent law in Hawaii. This isn't the case in all states. So Hawaii added it recently and some other states have it. But adolescents can actually consent to mental health treatment without their legal guardians, starting at age 14. And so this was intended to help support youth who don't feel comfortable talking to their parents about their concerns, but who would benefit from mental health treatment. So this is only for outpatient psychotherapy treatment, so like talk therapy in an outpatient setting. So it does not include things like medications or inpatient treatment. It's often used for school treatment if the school cannot get a hold of the parents, but a high schooler wants to receive school counseling, they can use this law to help provide mental health services to the teenager. As part of this, so a minor cannot cancel their parents' consent. So if the parents are wanting to bring their teenager to therapy, the teenager is not interested, the parents can still make the teenager go to therapy. But vice versa is true as well. So if a teenager wants therapy and their parents are trying to prevent them from accessing it, this is saying the parents cannot actually cancel the minor's consent. And just an interesting detail, a therapist can actually request that the health plan, so like Kaiser or HMSA or one of the other health plans, not disclose the services to the parents via insurance billing information. So it really can be kept pretty confidential for the teenager if they want to consent to their own services.